The U.S. Supreme Court recently modified the Miranda rule for questioning criminal suspects. Well-known defense attorney Jim Reilly of the Summit Defense Law Group is here to explain the practical effect of that new decision. Jim?
Yes. On June the 1st, the U.S. Supreme Court, in the case of Burgess versus Tompkins, ruled that for a suspect to invoke his right to remain silent, he has to do so affirmatively and unambiguously. It's not enough anymore to simply try to remain silent, as Mr. Tompkins did in this case, for more than 3 hours before they asked him before he answered questions, in order to invoke your rights. In other words, it's what's now required is for you to say straight out, I do not want to talk to you. I want to talk to an attorney before I answer any questions. For a criminal suspect, arguably, the Fifth Amendment's protection, which says you can't be compelled to be a witness against yourself, is the most important protection you have. And in order to invoke that protection effectively, you must never talk to a police officer about a crime. Never. No exceptions.
Well, wait, Jim. I mean, if you're innocent, wouldn't it be doing yourself a favor to help to explain that to the officers?
You might think so, but it's really not the case. Because what you say can be used against you later, but it can never be used to help you because it's not admissible on your behalf. So even if you're innocent and you tell the truth, the whole truth, and nothing but the truth, that can be used later to convict you. And if you tell us even a small lie or just make a mistake, I guarantee that's going to come back to bite you. So if you're approached by a police officer to answer questions about a suspected crime, the best thing to do is follow the new rule in Tompkins, tell him straight out, I do not want to talk to you. I want to talk to an attorney before I answer any questions.
All right. Well, hopefully you'll never find yourself in that kind of a spot, but if you do, this is really sound advice.